So as I mentioned, the process is started by a Form L, notice beginning of arbitration. Unlike any kind of other proceedings that you're used to, it's a form you fill out and you don't register it anywhere. You just send it to the other party. And same thing when you're responding, you have 14 days to respond and it just gets sent to the other side. And this is why I think a lot of times these arbitrations used to get sort of stuck. Somebody would send the dispute, the Form L, the other side would respond with a Form M, and then they were like, well, now what? They didn't know how to drive the process forward. And usually to drive the process forward is if there was an agreement, somebody would, about who the arbitrator would be, it would actually be contacting the arbitrator and saying, do you agree to decide this dispute? And then away you go. Once the arbitrator's been hired and that's been resolved, the arbitrator will drive that process. But until that happens, it sort of, nobody knows how to stick handle it to get to there. There's some stipulations about who the arbitrator can and can't be. So the arbitrator can't be a minor. They can't be an owner, tenant, occupant of the strata corporation. They can't be the strata manager, or they can't be an employee of the strata corporation. So essentially it's meant to be a third party that's unrelated to the strata corporation who is the arbitrator. So this takes us to the Civil Resolution Tribunal. This is now by far the most common way that strata corporations resolve disputes once they sort of hit that dysfunction stage. What the tribunal is now it's about, is it a year old? Just 2 years now? Yeah, 2 years in July. I can't remember. July 2016 is when it was established. So 2 years ago, the government sort of started up this Civil Resolution Tribunal. It initially started with only strata corporation disputes, and what it is, it's a dispute resolution place, online place, where they are given the powers to resolve most common strata corporation disputes that they would have with their owners and tenants. Eventually, about 6 to 10 months later, they also opened up the Civil Resolution Tribunal to deal with small claims disputes that are $5,000 or less. Next year, the CRT will also expand to include minor injury, motor vehicle accident claims, and disputes within housing associations established as cooperative societies or corporations. So, while most of you are probably real strata corporations, there are a few people out there who they look like stratas, they feel like stratas, but they're not. They're not established under the Strata Property Act. They're established under the Societies Act or the BC Corporations Act. Those have not been able to use the Civil Resolution Tribunal. The plan is for next year that they will also be able to use it. The tribunal members are the people that actually make the decisions that are submitted to the Civil Resolution Tribunal for resolution. They are mostly lawyers, and they resolve the disputes if the parties cannot resolve the dispute during the CRT process. So even once you start that process, there's still an ability to have a solution that's crafted by the parties as opposed to crafted by a decision maker, the tribunal member. Supposed to be quite user-friendly, so nobody has to travel anywhere to be heard, which tends to be a difficulty with people who have to go to, are summoned to courts as a witness, or if they're living far away from a courthouse, that could be really difficult for them. So you have this online format, and they sell it as you can, start your dispute, respond to your dispute in your pajamas in the middle of the night if you wanted to. I'm sure I could find something better to do with my time than do that in the middle of the night. But the selling point is that there's a lot of flexibility with respect to when and how you do it. So a tribunal, when a tribunal is established, like for example the Human Rights Tribunal, the Labor Relations Board, the Residential Tenancy Board, all of those tribunals are created by statute, by legislation, and all of their powers are derived from legislation. So unlike Supreme Court, which has what they call inherent jurisdiction to make all sorts of decisions and grant all sorts of remedies, the Civil Resolution Tribunal is limited in their powers to what's under the Civil Resolution Tribunal Act. And so you have to look at that legislation to see if the dispute that you're up against or dealing with is something that can be resolved under the CRT. So again, like I said, it was meant to deal with most common disputes, so there's sort of a laundry list of what those would be. So it's if you need to get a judgment against an owner for money owing to the strata corporation, those unfair actions by strata corporations, unfair vote outcomes by people who hold more than half the votes, bylaw disputes, either dispute that an owner might say they're disputing a fine, or it could be an owner saying that they're disputing the fact that the strata corporation isn't enforcing the bylaws. That could be disputed. Duty to repair claims, where an owner can claim that the strata corporation has breached their duty to repair by not repairing windows or the building envelope, or you name the common property. Those are those types of claims that can be brought by owners at the CRT. Compliance with governance provisions. That's the they haven't provided disclosure under Section 35 and 36 of the Strata Property Act. I've asked for these records. They haven't provided it. They didn't provide minutes within 2 weeks, just like the bylaws say, or they didn't provide notice of the AGM or SGM in compliance with the Strata Property Act. So it's all those sort of things that the Strata Corporation has to follow under the Act and the bylaws in order to govern itself. Those are the kinds of disputes that they can deal with if somebody says that they are not in compliance. Interpretation of the Strata Property Act regulations or bylaws. So sometimes there's a question about whether people might interpret things differently, so the Civil Resolution Tribunal will interpret them. They will also deal with the enforceability of a bylaw. So they will make decisions about whether a bylaw is enforceable, whether they've been passed correctly at an annual or special general meeting. Again, issues about common property or common assets. A common one that we see is, did the Strata Corporation, was the change in the common property, whatever change it may have been, was it significant that it required a 3/4 vote of the owners? The use or enjoyment of a strata lot, we don't see that very often, but usually it relates to somebody saying, you haven't repaired my unit, and now I've not been able to use my strata lot, and I'm claiming a bunch of money for that. So that you'll see that a lot. That's the kind of claim that usually comes up.